Buenos dias, my good people. Thank you for tuning in to episode number 7 of Welcome to Salt Creek. My name is Ray Fuentes, host of the show. Today I'm broadcasting to you all from the Salt Creek Beach, my home away from home. Now this is where I'd wake up at the crack of dawn and come down and surf before rolling into class at Dana Hills High School, just up the street. This is where my brother asked his beautiful wife to spend the rest of her life with him. Thankfully she said yes. And this is where I go to think about life and tune out the noise. Anyways, I thought it was very necessary to share some beautiful SoCal vibes with y'all for episode number 7, in addition to my conversation with the YouTube sensation Jeremy Hogan and the White Knight of the XRP community, John Deaton. Both are acclaimed attorneys who are well informed with the ongoing case between the Securities and Exchange Commission, aka the SEC, versus the payment infrastructure company, Ripple. Now, please be advised, John Deaton is also the attorney representing the XRP community after filing a motion to intervene in the case, forcing the SEC to exclude the XRP owned by us retail. So thank you very much, John Deaton. He's also a petitioner of a written mandamus, which is an order to our government to wake up and carry out their duties. But before I give away the farm and get any more excited about this episode, let's roll that famous intro and get down to business. Hello, hola, and bonjour. I'd like to introduce you to my lovely wife, Leah, our baby girl, Eden Ray, and yours truly, Ray Fuentes, host of the show, where I'll be sharing our journey as a family, conversations with entrepreneurs, tips for healthy living, and tools, products, services to help you navigate through this digital age. Thanks for tuning in, and welcome to Salt Creek. John and Jeremy, how long do you think it would take to create a regulatory body that fills the gap between the SEC and CFTC? Question 2, regarding the classification of XRP sales then versus now, understanding some employees may have taken an option for XRP, they're early employees of Ripple. If they left Ripple and used those XRPs to fund a new venture or part of their venture, do you think that this case could snowball into their operations?
Listen, I have no faith in Congress and politicians and our leaders. To answer your question, I'd say it would be lightning fast 18 months if you had a consensus, and I don't even see a consensus developing, quite frankly, even though there may be a little more bipartisanship related to this area. Listen, what is if XRP is deemed a security flat out, what's that make spark? Just curious, if XRP is a security, then the Flare Spark token that was generated and created, in essence, if you will, XRP gave birth, one could argue, to the Flare token, right? What's that make that? So I think that your thought process is on point. I believe that the SEC would potentially go after a second removed, if you will. Okay, you funded your operations from a security and then created another token, and therefore, I think that I don't put it past them of sending notices, creating litigation, to developing fines, right? I think they are a cartel, if you will, of generating money, and it helps generate their operations. So I'd be nervous if I was one of those individuals. When I say nervous, meaning, okay, we might get a notice if there's an adverse ruling in this case. And that's why I keep saying that, and like many of you, we've all been saying that this case, is a huge precedent-setting case moving forward for all of crypto.
I agree with John on, especially on the second point. Well, mainly on the first point, but absolutely on the second point, it would be a snowball effect. What we've seen though in the past, Raymond, is like, for example, with the Kick Interactive case, the KIN token has continued on, even though it was in essence declared a security. And the SEC hasn't shown any resolve to try to go after those smaller players. I mean, the truth is, the snowball effect you're talking about, the SEC just doesn't have enough attorneys to chase all those people around. So they're limited in a sense. Just to give you an idea, I think one of their attorneys probably handles about 20 to 30 cases. That's it. And they have to have 4 or 5 attorneys on every case. So, you're going to have thousands of attorneys if you're going to really chase any volume. They just can't do it. So although technically, yes, what you're saying is accurate, and the XRP that would be used to fund a new company would technically be a security. Hell, the XRP that I tip someone on Exum with would be a security if what the SEC is true, but they don't have the resources to go after all of them.
Alrighty, ladies and gentlemen, I hope you found this conversation as interesting and informational as I did. In a nutshell, this case is one of, if not the biggest cases of our lifetime, and it's gonna set precedents for the entire crypto space. I won't be surprised if this case gets dragged out until a regulatory body is given jurisdiction of the emerging asset class, or until one is created to fill the gap between the SEC and the CFTC. Please be advised, John Deaton has also launched a website, crypto-law.us, which acts as a central public resource for legal and regulatory documents related to the ongoing case, digital assets, cryptocurrencies, and blockchain innovation here in the US. I'll be sure to put his website below in the description of this video for those of you who want to become more informed. Now please tune in to episode number 8, where I'll be sharing my conversation with Bradley Kimes, aka Digital Perspectives, and the digital asset investor. With that being said, I'm out of here. I got to get back to work and sell some business insurance. Thank you for tuning in to Welcome to Salt Creek. Have a great rest of your day. Thank you.